About family justice. What you need to know about the guardianship of a child. What does being a guardian mean? As a guardian, you will exercise parental responsibility over the child below 21 years old for the welfare of the child. Who are considered guardians? Persons who are responsible for the welfare of the child include 1. Parents of the child and/or 2. Court-appointed individuals. When can you obtain guardianship of a child? The guardianship of a child can be obtained in accordance with the law or through court proceedings in the following situations. Situation 1. In the unfortunate event when one parent passes away, the surviving parent will obtain guardianship of the child as the natural guardian. If both parents pass away and there is no other person with parental rights, for example, a grandparent, an aunt, or an uncle, the court may, on the application of any person, appoint the applicant as guardian of the child if it is in the welfare of the child to do so. Situation 2. When a guardian is appointed in a deed or will made by one or both parents. This is known as a testamentary guardian. Situation 3. When the court replaces an appointed guardian with another guardian, if it is in the welfare of the child to do so. If you wish to be appointed as a legal guardian of the child, you can make an application as a non-parent under the Guardianship of Infants Act, or GIA, to be formally appointed as the legal guardian of a child in the situations earlier mentioned. In the absence of these situations, a person, even if he or she is the parent, cannot apply to be the legal guardian of the child under the GIA. An interested person will need to apply to the court to make the child a ward of court, provided that it is necessary to do so for the child's welfare and protection. For example, if there is no fit parent having parental responsibility over the child. This is a high threshold which the interested person needs to satisfy the court. In such a situation, the court will become the child's legal guardian and has ultimate guardianship of the child, and any important step in the child's life will require the court to provide approval. If you are the parent of the child, you must have a good reason if you wish to appoint someone else as a guardian of the child, as parental responsibility cannot be voluntarily delegated. The court must be persuaded that the appointment of a particular person as a guardian is in the welfare of the child and not for mere convenience. The court process. If you choose to engage a lawyer to represent you, you should do so as early as possible. You can refer to the above resources for more details. There are 3 stages of the court process you need to know. Beginning with the application stage. To apply, you need to prepare and submit these documents in the Family Justice Courts, or FJC. An originating summons, or OS, containing the specific requests that you are seeking the court to grant. An affidavit in support of the OS containing your reasons and evidence to persuade the court why you should be appointed as the legal guardian of the child. If parties are Muslims or were married under the Muslim law, you may need to obtain permission from the Sharia court to commence or continue proceedings in the FJC. For more information, please see the Administration of Muslim Law Act, Chapter 3. Where to file documents. Submit the documents electronically via the e-litigation system, or e-lit, at the Crimson Logic Service Bureau. If you have a lawyer, your lawyer will do this for you. You may visit the Service Bureau's website for more information. If your documents are in order, the court will accept your application. However, this does not mean that the court has granted your application. You will need to collect the documents from the Service Bureau once they are ready. You must serve a copy of the originating summons and affidavit to the defendant, who is usually a parent of the child, to alert them that you have started these proceedings in court and inform them of the first court date. Next is the case management stage. The court will fix case conferences where necessary that are compulsory for parties to attend. For example, when the court needs to clarify parties' positions, or give directions for either party to file further documents, so that the court has a better understanding of the facts of the case. The court may direct that parties attend a case conference even if both parties consent to the application. If you have a lawyer, Your lawyer will attend the case conferences on your behalf. Similarly, if the defendant has a lawyer, his or her lawyer will attend the case conferences. If the defendant disagrees with your application, he or she will have to file an affidavit in response to your supporting affidavit. The judge will check that all the necessary documents have been filed and fix a hearing date for a judge to hear the case. The next court attendance would be the originating summons hearing. If you and the defendant reach an agreement at the hearing, the judge will record a consent order if he or she agrees that the order sought by both parties is in the best interests of the child and should be granted. If you and the defendant cannot reach an agreement, the judge will hear both parties' submissions and review the affidavits filed before making a decision. In making its decision, the court's foremost consideration is the welfare of the child. Once the court has granted the order, you will need to extract the order of court via e-lit through the Crimson Logic Service Bureau. Your case formally ends once the court has granted the order. For more information, please visit the FJC website. You may also find the information on the following websites to be useful. 1. Guardianship of Infants Act. 2. CJC.